A warm welcome to everybody. We can begin with the important topic of justice, and the keynote speaker is Professor Gianluigi Palombella. Gianluigi Palombella is a legal philosopher. His works about global law and rule of law are well known in the community of legal philosophers and scholars of international law too. But he doesn't. It no needs introduction, so over to you, Professor Palombella. 45 minutes for your presentation. Thank you.
Grazie. I have the honor to be of the cooperation of Professor Velluzzi, who will put his finger on the bottom of the slides and will help me. Okay. Yeah, so under this title, Access to Justice as a Right to Law, I will try to outline justice in the context of the European Union and other international legal instruments. Of course, as you all know, justice is among the fundamental commitments, I would say, values of the international community. But before we start, I thought it was useful to see what is the frame of the rules that are relevant here. I have just listed some of them. As you know, from the Magna Carta Libertatum to the United Nations Declaration of Human Rights, the International Covenant on Civil and Political Rights, importantly, the 1998 Aarhus Convention, the Convention on the Rights of Persons and Disabilities, and then, for our concern especially, the European Convention on Human Rights, especially Article 13, that guarantees effective remedy, and Article 6, a right to a fair trial. And in the section concerning justice of the Charter of Fundamental Rights, Article 47. Notably, according to Article 553, the rights enshrined in the Charter are to be given the same meaning and scope as the corresponding ones that are laid down in the European Convention. And thereafter, you might see the text of Article 47. Now, this said, this being the frame, despite such a rich array of good norms on the international level, we perfectly know that dispossession of rights and rights devoid of effective protection do really abound. Think, among many issues in the transnational sphere, of the major example, I believe, is the recent present migratory fluxes that are before our eyes today. Crowds of people that are left to injustice, are left to iniquity, in a lawless limbo. And this is also consequential to the tragic impairment of their rights in their country of origin. Therefore, we might say that injustice spreads within and outside the state. You might recall how Hannah Arendt put citizenship as the right to have rights. That is something preeminent and premised upon any other. So rather than a fundamental right, the legal belonging in a country was thought of, or at least I believe so, as a foundational, not fundamental right in the legal system sense, but a foundational right. However, realities have ended up turning such an assumption into ambiguity. At least after the Second World War, the citizenship of a person determines how she is treated, what rights she is entitled to. So citizenship, well, that will be treated tomorrow, I believe. But by the way, citizenship is a slippery concept and a slippery right. Variations depending on the relevant states, whether poor, wealthy, democratic or undemocratic. On the other hand, rights universalization would require to overcome the exclusionary limitations that are connected to the category of citizenship, at least as it is framed and used today. Therefore, is there any further candidate to play a role comparable to Arendt's citizenship as preeminent vis-à-vis liberty or justice itself? Well, I believe there is one, and that is access to justice. A right to the protection of law itself. Something that in the present positivization of human rights resembles the significance of a right to have rights. And it is not so much a novelty. If we look back to the modern philosophy of law, it speaks of the construction of civil society. But that construction depends on the birth of law. And the birth of law entails the possibility of access to justice. And in turn, access to justice means to have finally, eventually, a right to law. So if we look at Kantian philosophy, for example, there is a difference vis-à-vis his Kantian natural right of liberty, because, of course, access to justice is not just a fundamental right, but a foundational one, in the sense that it really separates, well, Kant will say, state of nature from the civil state. It separates, in truth, violence from law. It is a right to be ordered by law. And therefore, it is also a condition of, not of justice as such, but it's a condition of conceivability of justice. Now, what access to justice is, it's very difficult to say. But in this overview, let me say that it has a dual nature. And it is contended upon, I believe, at least three couples of opposites. The first one is access to justice is a structural feature of the rule of law, or the opposite, a fundamental right. The second couple, is it an essential or core right, or as many procedural rights, it's just a subordinate and derivative right? And the third one is, what is it serving for? Is it serving public interest, or is there for the interest of the individuals? These are milestone questions, of course. But let me start. Well, is it a structure of the rule of law, a rule of law structure? Well, it features among the very requirements of the rule of law, according to those scholars that do define the rule of law in what has been called the morphological or anatomic way to understand the rule of law. So it is something that is essential to the rule of law. On the other side, and tellingly, some of you, or all of you, might remember what Joseph Ratz was saying about the rule of law, and it's significant. He says human rights deprivations are considered by him, largely compatible with the rule of law. But the principles of natural justice, including access, that means absence of bias, fair hearing, judicial independence, are necessary to the rule of law. And because, of course, they pave the way to the correct application of law, and also to the aim of the law that for us is to guide behaviors. Now, so here we see how access to justice is a pillar of the rule of law, and it is so regardless of the content of law itself. Therefore, regardless of whether human rights are guaranteed, or even, or not all of them, or all of them, or if democracy is fading or is full. So it is a foundational structure, and it stands even if it is, if it were not a fundamental right. Why? Because it's a cleavage. It's a cleavage between law and lawlessness. Therefore, the question becomes, being a requirement of the rule of law or being a fundamental right, does this make any difference? In practical terms, it is a relevant question. Well, I make an example here, also for, we are always short of time in these cases, so I'll just make an example. In 2004, the Supreme Court of the United States decided the case Rasul versus Bush and granted habeas corpus to Guantanamo detainees. It did so, mentioning human rights and dignity and so forth, but especially by a basic argument. That is, that access to justice, that's the same thing here. Habeas corpus is a limitation of the preponderant and therefore worrisome power of the executive. Therefore, Guantanamo cannot be used to get the executive free of legal ties. So, as you see, it's a structural reason, not a right. Now, what happens 2 years later? That the Congress, the United States Congress, issues a military commission act deleting habeas corpus for aliens because it is a right. You follow? As a consequence, at the District Court of Appeal of Colombia, all detainees saw their application for habeas corpus rejected because it is a right. That means a constitutional right, as such, reserved to American citizens. It's not pathetic, but moving somehow, the fact that one single judge was dissenting, and in his dissenting opinion, Judge Rogers wrote in order to grant habeas corpus to Guantanamo detainees, that, well, habeas corpus is not a right, is not a fundamental right, because it is a limitation to the power. So it's a structural construction of the government. It's a limitation to the power, in this case, of the Congress. So it must make some difference depending on the context. The other couple is serving the public or the individual interest. Well, the European Union case law alternates instrumental to essentialist justifications. So you see that instrumental arguments are valuing access to justice, or say the participation in administrative procedure in order to protect the community interest. But essentialist arguments do preserve access to justice for its own sake and the sake of individuals. So there is an oscillation between the two. And of course, this is perfectly legitimate. Well, one should say so far that it must depend on the open, dual but open nature of access to justice. Anyway, the other couple is access to justice as a core or derivative right. Well, if it is a derivative right, then it is serving the substantive right that is the reason for justice. So, access as a procedural right, serving subordinate to the substantive right that is claimed in the court. The right to health, the right to property. Think of the Charter of Fundamental Rights. Article 41 provides for the right to be heard. But it is a component there of the right to good administration, the substantive right. That matters. Think of the right to information. That is the point of Aarhus Convention, but also in the Charter and the other European frames. You see that information can be subordinate to the ultimate value of the right that it is serving. The substantive right, again, of property or health. Now, if property in the circumstances of the case has to prevail after the balancing that is needed, then access to justice will prevail, otherwise not. So, the fact is that courts can describe a right as a core or derivative right depending on the fundamental interests that are taken to justify it and those that are going to be prioritized in given circumstances. And this happens frequently, and again, this is perfectly legitimate. What is the legal frame? If we look at the legal frame in the Charter of Fundamental Rights, the general impression is clear, is that access to justice is derivative by construction. Because, of course, in the Charter, Article 47 explicitly, a right of access to justice is guaranteed only for the situation where the rights and freedoms protected by the Charter have been violated by the European Union institutions. Not as such. And the same applies, holds true for the European Convention of Human Rights, Article 13, where it is protected in order to safeguard the rights enshrined in the Convention, that, by the way, are not including social and economic rights. The good thing is that, however, courts are smarter, of the construction itself, and they do enlarge, expand the right of access to justice, even beyond the strict legal and narrow channels, and make less clear-cut a distinction between a core right or a derivative one. So one, perhaps the biggest, the most important issue under access to justice is the substantive one. Whatever we do, we must be sure that it is not formal in the abstract sense. It must be something effective, something that really works for justice. So effective remedy, that is Article 47 of the Charter of Fundamental Rights. And there is provided both effective remedy and fair trial. So what is the most important, I believe, point in commenting this? The effective remedy. Judicial independence, I believe. Judicial independence is a pillar for the real justice. You know that an expedient strategy to drain and empty access to justice by circumventing its core sense without denying formal access to justice itself. It's to submit it to, the judiciary or parts of it, to political bias and the whim of the government. Think of Hungarian or Polish policies and legislation undermining judicial independence by modifying age retirement of judges and those and those subsequent acts that are reducing the freedom of even of constitutional judges to protect constitutional freedoms. Well, it's not just a unique case. It's not a novelty. Why shouldn't we think of Franklin Roosevelt court packing in the 30s of the last century? Well, he had the intention, but he was very fortunate. It was not necessary at the end. But the intention of court packing he had in mind was meant to make the Supreme Court capable of accepting its New Deal legislation and granting to it constitutional conformity. So there is no institutional difference. From the institutional point of view, there is no difference between Holland or, apologize to the Netherlands, Poland or Hungary, and court packing. Of course, there is a big difference in terms of substantive values, of political intentions, of culture and civilization, but still, it's under-civilized to try to undermine judicial independence. That means to jeopardize the distinction between jurisdictio and gubernaculum, the difference, the fact that jurisdictio should not be overwritten by gubernaculum and political and the sovereign power. Another case that is well known for effective remedies, a problem is, have been for decades, perhaps for centuries, social and economic rights. They have always an uncertain fate. I will not go into details, but, well, at least we know, as Professor Van Parijs told us in the car yesterday, at least we know that there are the provisions. And the Charter of Fundamental Rights put provisions protecting social and economic rights under the chapter Solidarity that will be treated separately. So I will not intrude into that, but still, the point is that justiciability of social and economic rights is disputed and often denied on the basis of stereotyped arguments, like, for example, that courts should not interfere against social distributive policies, whether for lack of democratic legitimacy or for lack of competence or capacity, and that's it. Good news, anyway, that courts have started since decades now, and especially Constitutional Court, to address social and economic rights. Why and how? Well, by giving definitions for the fair wage, the right to education, the right to basic health measures, and so forth. And also by adjudicating disputes, especially in Italy, for example, legislation, on the basis of balancing of principles, balancing of values, and proportionality, and in Italy especially under the canon of reasonableness. But if there is a case that I believe is really impressive for effective remedy, is what I call the strange case of environmental rights. It's so interesting, also because it's in progress, but it's so interesting for one special thing that, as we know, after all, it's a procedural, access is a procedural right, but it determines substantive consequences, not in the obvious sense that it determines the protection of something, but because it produces new rights. It does something that is not known at the start. In other words, it makes it possible to foster the understanding or clarification or even the recognition of rights that until that point were just recommendations for legislators or for the behavior of governments. Not individual rights with the power to stand before a court. So this is the point I wish to make on environmental rights and the effective remedy. So the European Union, what about it? It's in environmental issues after 2005, after ratifying the Aarhus Convention. But private entities in general have been experiencing for a long time impediments to the standing before a court, because NGOs and individuals are banned from the court, or were banned from the courts in environmental field, against European Union acts or against national acts violating European Union directives or regulations. Neither in the European Convention nor in the European Union as such we find any actio popularis, I mean an action going to defend collective rights of the public as a whole in environmental cases. And if you read 263 article of the Treaty for the Functioning of the European Union, I hate this, but it's... You see that there are the requirements for standing that are so old and so traditional, and more than that, even interpreted by a very conservative interpretation, the reading that is the so-called Plowman Doctrine. It means that NGOs are banned from the courts because, according to the requirements for standing before a court, they cannot be individually concerned with environmental damage. At least it was so until the Protect case in 2017, or at least I think so, where the Court of Justice of the European Union decided that NGO is standing in the court for issues concerning the use of waters under the European Union framework. It was a case raised by Austria. But we don't know precisely if it holds for NGOs, but we don't know if it holds also for individuals. We will have to wait another case that has been raised by the German Federal Administrative Court last year as a preliminary reference. But you see, this is the starting, well, not the starting, it is one of the series in the litigation series. So litigation is a really good thing. And of course, it's a case in point for access to justice. It's the phenomenon of access to justice in action. And it triggers a virtuous circle. A lot of things happen just because the standing is permitted. You see all the cases, two other cases that I have listed there. There are also many others, but the one is 886 Dutch citizens that, represented by Urgenda foundations, were able to reach the Hague District Court in 2015, and can you imagine, they obtained a positive decision requiring the Dutch government to adopt a number of measures to mitigate climate change. We are operating in the vagueness here, but still they had the provision granted from the court. 21 young people suing the federal government, again the same thing, for allowing the exploitation of fossil fuels. Can you imagine? I mean, any country in the world is allowing since decades, centuries, the exploitation of fossil fuels. Can you imagine the litigation on that matter? Well, there is no jurist in the United States that would say, yes, of course, you should grant access to justice to these Juliana versus United States so-called kids climate case. No one. But they found in Oregon a judge that granted them access to justice with a lot of good motivations, but there is one that is very important, and it's supporting what I said at the start about the productivity of a procedural right towards substantive consequences. That is, Judge Anne, well, a woman, of course, Judge Anne Aiken, that at the end said, must be granted because in the situation of unsustainable catastrophic level of our environment, we should think of a right, it's a new right, to a climate system capable of sustaining human life. Now, the turn was, after all, in Europe after the Paris Agreement 2015 into force 2016. From then on, it seems that, as a matter of fact, access to justice has become a kind of generator of substantive protection. That means not just the way to greening, to use pre-existent rights like life or property as useful to face and address climate change or other environmental issues. Something different, something more, that is to prepare for the new sensibility, that is to forge a substantive right to a healthy environment, something that was advocated 2018 by the previous rapporteur for human rights, Professor Knox. And if NGOs already have got the standing before a court to defend single rights, the rights of individual to property or to life after environmental damage, the reason for extending their standing before a court is precisely to protect the environment as such, the environment as a whole. That is the point of Aarhus, of the Aarhus Convention. We are a bit late, but we are right. Yeah, the law against access to justice. I couldn't help. This is something that I want to say because all the optimistic attitude I showed about this service of access to justice as a foundational right, something that constructs and makes for the law itself. Well, there is a big contradiction operating regularly. That is that often it is precisely the law against access to justice. And there are cases where the rule of law is invoked to foreclose access. And this happens, of course, especially when two different orders or two different legalities are in conflict. Say, European Union law and international law, or one of the two vis-à-vis domestic law, national law. To explain the thing, let me make shortly, briefly, two cases. One of the most well-known and milestone case in the European Union law for other reasons has been the CRID case. The Security Council of the United Nations issued a resolution ordering the relevant states and the European Union to freeze the assets of Mr. Cadi that had been, by the Sanction Committee, blacklisted as an Al-Qaeda affiliate. Immediately after, the European Union, with its own regulation, did freeze the assets of Mr. Cadi in order to implement the resolution of the Security Council. As a consequence, Mr. Cadi went to the court, to the European Court, and claimed that the European regulation was illegitimate because it had infringed his right to access to justice. Better said, his right to a judge, his right to a defense, to know the evidences and the charges against him, the evidence and the charges against him. And of course, also his right to property. Of course, this is a violation that was not something happening in the European Union, but something happened at the time of the blacklisting by the Security Council. It was blacklisted as anyone else on the basis of classified information. That means secret, something that the victim of the blacklisted defendant could not know. So there was, at the time, no access to justice at the Security Council, and the implementation by the European Union was, of course, something supporting such denial of access to justice. Now, what was the answer of the European Court? Easy. The answer was that the rule of international law, that is a species of the genus rule of law, the rule of international law provided for the supremacy of the Security Council resolution according to Article 103 of the United Nations Charter, and therefore it was not for the court to scrutinize the legitimacy of the resolutions of the Security Council. So as you can see, the rule of law against access to justice. Fortunately, 3 years later, 2008, the European Court of Justice declared that the regulation of the European Union was illegitimate because it was violating the fundamental rights of CADI that were part of the primary norms and the constitutional traditions in the European Union. I will not go in depth into this, but one thing that I will note here is that in the reasoning of the court, something for comity, perhaps vis-à-vis the international legal order, for hypocrisy vis-à-vis the international legal order, was not said. That is, that the denial of access to justice was not just something that happened in the European Union, but it was a failure in the general international system that do protect human rights, and among them, fundamentally, access to justice as such. Germany versus Italy is the last case. Well, I've written a lot on this Germany versus Italy. That has been a very disputed and controversial decision of the International Court of Justice that in 2012 declared that Germany, of course, must be granted. It was Germany versus Italy, but the result was different from that you can remember. Professor Zanetti did not get it, but it was 4-3 in favor of Germany, in favor of Italy. This time, Germany did get the pronouncement on the basis of the primacy of the immunity of states, customary rule, that is fundamental rule in international law, and of course, is protecting the principle of sovereign equality among states. But this principle had to prevail over jus cogens rules. Immunity meant that Germany is immune vis-à-vis Italian tribunals in cases concerning compensation for the victims of war crimes and crimes against humanity. But immunity must prevail against jus cogens rules prohibiting such crimes and infringement of related rights. Notwithstanding the absence of any other means of redress. In principle, this is a very large and deep question to be debated. When the thing for the right roots reached the Italian Constitutional Court, to tell the long story short, the Constitutional Court said that despite the obligation to comply with the decision of the International Court of Justice, that is Article 94 of the United Nations Charter, the Italian constitutional order cannot accept the decision because it contradicts the supreme principles of the Italian Constitution, and in particular Article 2 defending human rights and Article 24 defending, protecting access to justice. Now, it was, as you see, another casus belli between two different orders, two different legal orders. I wish to interpret in the optimistic way the decision of the Italian Constitutional Court, assuming that objectively and regardless of the intentions of the drafters, that paves the way to the implicit statement that, legally speaking, legality devoid of access to justice ends up missing its basic reference to justice. The autonomy of access to justice in all the sets of these cases seems to be a matter of more fundamental importance than other norms and principles, be they of the Europe, of the European Union, or of the Italian constitutional order. More than that, empty access to justice is tantamount, as I said at the start, and I'm going to conclude, to making the law fade. And it might seem just a nuance, but it is not. While the disregard of a human right, or more than one human right, by a legal order might make its records at odds with international law, or expose the conservative authoritarian culture of that legal system. The denial of access to justice does something that is really more radical. It revokes the legal status of the normative structures that are in place. And the wider such a denial, the deeper the undermining, not just of a right, the deeper the undermining of a legal order as a whole. So that's it. Thank you very much.
Thank you very much for your presentation, Professor Palombella, so deep and clear and relevant for a general theory of the relationship between justice and rights, from my point of view. Now it's time to listen to the discussant, Silvia Zorzetto. Silvia teaches legal theory here at the University of Milan. And so, Silvia, tell us your opinion about Palombella's thesis.
So, thank you very much. I'm delighted to be here, and I wish to thank all the organizers and you all for attending this conference. The opportunity to comment the presentation of Professor Palombella is a great honor for me. And it is also a very difficult task, as the matter of justice is extremely controversial, and the presentation and the paper are ambitious and penetrating. The paper, which I have the opportunity to read in advance, is even more rich and more challenging in respect of the presentation. And of course, my paper has been, my comment has been presented, has been prepared, taking into account the paper. And so, in a sense, I will start from the end of the presentation of Professor Palombella, because in the paper, Professor Palombella explained thoroughly all the topics that he presents here, but also he proposes an important thesis, theoretical thesis, about the foundation of the justice as a fundamental, or rather a foundational right. And so this will be the focus of my comment, and in a sense I will leave aside all the very clear and interesting picture that he portrayed right now about the state of the art of the case law and of the normative panorama about human rights in the contemporary debate. I don't know if at the end I will have time to tackle very shortly a more specific point about the relevance of public interest, but in case we will have the opportunity to discuss it at the end. So, Professor Palombella outlines his basic thesis at the beginning and at the end of his paper. I'm quoting his word: the effort towards human rights, their definition and entrenchment made in the last 70 years brings before us a candidate, being their fundamental premise. The candidate to such a foundational place is the right of access to justice. I'm still quoting: the access to justice is not just a fundamental right, among others, since it is a foundational right, in the absence of which the entire edifice of legal civilization falls apart. Therefore, the author argues that justice should be conceived as a right to have rights, and such rights being those embedded or implied in a certain rule of law ideal. We could say that for Professor Palombella, justice in its proper form is a claim which is part of a legal system based on a certain rule of law ideal. Such claim lies the foundation of the law itself. In the paper, I think that which is the rule of law conception that he assumes, and hence which is the cluster of rights that in the name of justice we are entitled to claim, remains in a way unspoken as a general premise of the essay. And of course, here I cannot help worrying about its precise content, but I suspect that one of the reasons of this restraint in saying which are the rights that we have the right to claim in favor of is that a general approval of justice as the right to have rights can exist only if the demarcation of the various relevant rights or sub-rights is left undetermined. Professor Palombella does emphasize the dynamic dimension of justice, which he describes as something which can only be pursued continuously rather than a matter of fact or something which is found once at all. And I'm perfectly agree with him, and in this sense we have a sort of commitment or moral commitment if we think that these values has to be pursued. He also stresses the problem of the effectiveness or efficacy of human rights, as also in the slides has been explained. And moreover, Professor Palombella rightly underlines that the notion of justice does not depend on citizenships. In the paper, there is a very interesting analysis about the debate, starting from the ideas of Arendt, etc., about the contested link existing between justice and citizenship. And as Professor Palombella illustrates in his paper, many theories and the history itself demonstrate that justice and citizenship have been related along the centuries, and they often today continue to be related. But of course, two such concepts should be linked by definition, in which we could no longer find the one without the other. But we should discuss the opportunity of such definition, and certainly, according to the law in books and the law in action, in most cases in the world today, the reality is that justice does not rely and not depend on citizenship and vice versa. In fact, citizenship does not guarantee per se any justice, and justice is not limited to citizens according to most of the legal systems in force worldwide. National and international laws contribute to define the access to justice, by which understand the access to the courts, and therefore the right to have rights and limit in some ways and with reference to certain categories of people or persons. And in my opinion, this part of the author analysis is very intriguing and deserves to be expanded and detailed. A separate point, which should be a separate but in a sense, of course, related point, which should be clarified, is the notion of humanity and human being, or to be more precise, of the holder of the rights, which the proposal entails or addresses. In other words, who has the right to have rights? Which kinds of individual entities are entitled to claim of justice? Professor Palombella does not state explicitly all his beliefs about this point, and in a sense, he leaves the impression that the answer could be quite obvious, but also as his reference to some contested cases where the legitimacy was not so clear. In my perspective, show how this specific topic should be clarified, and is one of the issue where it appears the problematic relationship between the normative and moral positions about human rights. I do not intend here to present a different normative position or to challenge the proposal of Professor Palombella. Just the problem that I think that it is open to debate and it is interesting to discuss is that humanity and justice are both very complicated and value-laden philosophical concepts that have central and clear instances, but also highly ambiguous, variable, and controversial marginal cases. As regards to such margins, we could consider it as a typical, essentially contested concept. And whenever we discuss about justice and human rights, we should clarify as much as possible what we mean with individual in the philosophical meaning of the term. And so who are the collective bodies, the individual entities that has this right of access to justice? At all events, the main feature of Professor Palombella's proposals, as I said, is his critical conviction that justice as the right to have right is much more than a fundamental right. It is neither just one of the numerous fundamental rights that populate the present era of rights, nor the most important of them. In this respect, Professor Palombella distinguishes his proposal from many other authors, as well as the ideas that nowadays inform the actions of various courts and institutions. For instance, we can remember the normal way in which also European institutions define justice. Reference is made to one of the many handbooks of European law and relating to the access to justice prepared by European institutions, where justice is presented as a right or guarantee to go to court or any way to obtain a remedy in case of violation of a right. As an enabling right, it helps individuals to enforce other rights. And we see again the importance to understand which are those individuals and which are the rights that we have the right to claim in favor of. Access to justice encompasses a number of core human rights, such as the right to a fair trial and the right to an effective remedy. Professor Palombella amends this view by presenting justice as something more. And if I may, I found a little bit surprising to speak about a foundational right rather than the foundational right, because speaking about a foundational right, particularly if it is conceived as the right that marks the birth of positive law, as he wrote in the paper, in this perspective, I think that the foundational nature should be unique, so the access to justice should be considered to be coherent, the foundational right, and not just one of those. Another intriguing point of his proposal regards the foundational quality ascribed to access to justice. In the paper, Professor Palombella showed that his inspirations springs from the Kantian ideas. He writes that in Kant's reasoning, a legal society is a condition of conceivability of justice, and law and justice are resorted to conceptually in order to avoid and live a lawless state. I assume that Professor Palombella believes that, and saying that, believes that law and justice are conceptually connected in some way. However, I noticed that according to this reference to Kant, the access to justice is not a previous respect to the existence of law, while Professor Palombella affirms that the autonomy, and also he had some reference at the end in his last words about autonomy of the right, the autonomy of right of access to justice as a core right, and that has a foundational nature respect to positive law, or in some other part of the paper, legal civilization, or again, the rule of law. I think that all those references are, of course, very important, but these fluctuations of lexicon and references also leaves open some problems, because, of course, the rule of law is not equal to the positive law, or we could have a different conception of rule of law and also of positive law. And in which sense, and this is a genuine question that I submit to Professor Palombella, in which sense he is speaking about the autonomy? In which sense the right of access to justice is autonomous? Does it mean that it is a necessary and sufficient character of a legal system to exist, that being considered as such? And of course, this thesis is very close to some very traditional assumptions about the relationships between positive law and some other kinds of law, or a law that exists independently from the humans or the laws that we promote in our world, and in which sense? So, it is not completely clear, in my perspective, if the proposal of Professor Palombella and the idea that justice as the right to have right and the right of access to justice as a foundational right is a claim about a legal or a moral right. And so if we are speaking about in the legal domain, within the legal domain, or we are making a moral proposal about a moral foundation of a right that, as in its moral nature, gives a foundation, a moral foundation to the law that we have in our legal systems. Maybe this, I fully understand that this distinction between law and morality could be not relevant in some perspective or according to some ideas, and it's just, I think that in any case, it is important to clarify this point, just to make our discussion more close and to understand the lexicon and the respective position. I would have some other topics to deal with, but as the time is almost over, I just make a reference to the case, the last case that Professor Palombella referred, that I mean the decision of the Italian Constitutional Court in the case between the claim against the German state. And so Professor Palombella, about this case, affirms that the protection of justice has forced the court to find its own way to circumvent the dogma of hierarchy of the sources of law, but has also paved the way to the implicit statement that legality, devoid of access to justice, ends up missing its basic reference to justice itself. And in his opinion, customary rule of international law concerning states' immunity was the value contrasting the right for access to justice, and the reasoning of the court centered upon the question whether any higher international norm and public interest could displace domestic norms. I fully agree with Professor Palombella that this case raises a conflict of values and legal norms pertaining to different levels of legal sources and orders. However, the conclusion which I draw from this sentence is that the range in which the access to justice is guaranteed is a contingent matter, and it depends on the content of values, rights, and norms which are considered relevant in each case. In this respect, I'm tempted to conclude that public interests and single norms, regardless of their origin, can reduce or enlarge the access to justice. And finally, it does not seem to me that judges, or at least some judges, have abandoned the notion of hierarchy of legal norms. In fact, hierarchies keep being at the forefront of the legal reasoning and adjudication. Even the frequent appeal to justice as a meta-right or as the right to have rights that has a supreme status and prevails even other fundamental rights is, in my perspective, one of the most clear examples of the importance of hierarchies in the nowadays reasoning and legal adjudication.
Okay, thank you, Silvia, for your comment. Professor Palombella, want to say something about? Then we will open the discussion. So this is the best way to open the discussion.
Thank you.
Professor Palombella.
Thank you, Silvia Zorzetto, for this reading of the paper. I suspect that whatever I could have written would have triggered the same, similar, or other of the same relevance objections. When you have to speak about justice, either you write a couple of books and then you shield yourself from that kind of very fundamental, as much as minute, kind of clarifications, or otherwise you expose yourself to this kind of question: what is humanity, for example? It was too big an issue for me to define humanity in 3 lines, or say which kind of individuals are protected by justice in the European Union. It is not written in the rules, but judges know. And if strange cases happen to come to court, then you'll get also definition of the individuals that are allowed to the protection. Anyway, yes, I understand that if one reads things like this as, it's irresistible, the temptation to ask such questions. I don't think that they are necessarily the scientific point of view to be taken, but anyway. The first, I will not answer all of them. I've just touched upon a couple of things, and maybe we can discuss privately the rest. But the point here is whether since I connected the rule of law to justice and justice to the rule of law in a way that justice is something of the constructive feature of the rule of law, then I should have given a definition of the rule of law. Maybe you know that, Silvia, that I have, at a certain point of my life, I thought I had just written about the rule of law. So it was not something that I wished to start over again in this paper, finally, and luckily concerning access to justice. But I was not contending any definition of the rule of law. I just put the rule of law in one of the oppository couples. And I said, is it a structure of the rule of law according to some, or according to others, it's a fundamental right or a right? Therefore, I said, the rule of law, when defined by some scholars under the anatomic or morphological mode, does include access to justice in very different, many senses that are all convergent in our intuitive idea of access, and also in the same idea that the rules do provide for us. Therefore, I'm not under the obligation to define my definition of the rule of law. That was one of the times in which I was exempted from that, and you want to make me subordinate again to give definitions of the rule of law. I was not in any duty, I believe, scientifically speaking, to go ahead in depth in the rule of law definition, given the role that the thing had. Okay, I will finish, but let me say something, one more minute. I believe it's relevant what you say about hierarchy. Hierarchy matters, hierarchy holds, hierarchy applies. There is no way to think that in the case of, for example, Germany versus Italy, we had something that was dispelling hierarchy. No, there is a rule, Article 94 of the United Nations Charter, that says that for every state adhering to the United Nations, the obligation towards Security Council is prior to any other obligation that a state on the European Union might have taken previously, and even after. And that's one point, but that's Article 103. Article 94 says that the pronouncements of the International Court of Justice are mandatory to be implemented by states. That's about the dogmas of international law. The Italian Constitutional Court said, no, I will not do that. That's not hierarchy. And there are a lot of cases in which hierarchy is not the case, in the sense that it is impossible to solve disputes according to hierarchy. So I believe that for a legal theorist, hierarchy in between orders is a matter that gives certainty. tranquility in our psychology of scholars. But believe me, hierarchy, and I believe in this moment, given the circumstances of the interrelations among orders, hierarchy is not the final solution for our problems, and even less so for justice. Anyway, thanks, and I know that there are other things that you said that are very interesting, but I'm not going to answer now, of course.
Thank you. Now we can open the discussion. 2-3 questions at a time, and then the answers. Okay. Please.
So I accept only charitable questions.
Very charitable. Yes, thanks a lot. And I think I very much agree with your baseline. But since Silvia pointed out that there is a Kantian background, let me start with the idea of a general history in the perspective of cosmopolitanism. Yeah, there Kant points clearly out that it's an important challenge to make law hold at all in a society. That's somehow the fourth or fifth sentence of the idea in cosmopolitan perspective. And I'm wondering if to point it down to the point, to the term where I think I would want to get more clarification from you is the idea of independence of the judiciary or of the rule of law. I mean, you introduced the independence with respect to Poland and Hungary and the attempts to pack the court from the government side. And that's obviously an important kind of dimension of independence. But I think many of the controversies at the moment, and especially also the controversies surrounding European law, were about doctrinal value independence of the judges. Yeah? I mean, if the European Court of Justice is seeing kind of human rights for corporations, there's the impression that there's a certain liberal agenda in the background that is making these judges not independent. So in this respect, I would wonder if you would be willing to go farther ahead with the conception of independence. And now I would suggest, obviously, maybe a different idea of the rule of law. I don't know too much. More of a Kelsenian positivism of somehow say what is relevant for there to be the rule of law in a kind of a society full of tensions, conflicts, and so on, is that judges are not kind of the proponents of specific value perspective, of specific normative agendas, also as a criterion of independence. Because otherwise, I could only see them as co-legislators. Yeah. Yeah, for instance, defending a liberal agenda. Yeah, I mean, if you look at the... Yes, obviously. Okay, thank you.
I'm not sure it's a charitable question. It's rather a question requesting charity on your part. I would just like you to spell out a little bit the background to this interesting Germany versus Italy case. Who was exactly demanding what? What triggered the case? I understood it's a case that went to the International Court of Justice in 2012, but what preceded it? So how did it go that way? So who asked what? To what institution?
Yeah. There are many levels, many phases of judicial independence. I hope that you were not expecting me to treat them all, also because judicial independence was just one example of many things in my paper. That was an overview. And to do an overview is not an easy task because, of course, You look at things from the macro perspective. So this does not mean that I don't see details. I have tried to see some details. But, I mean, sometimes I realize that, how I say to my students, that is, when you write a paper, doctoral students, try to make a Michelangelo's fresco. What I believe it distinguishes those kind of frescoes is that if you zoom out, you see the entire very clearly. The whole of the fresco. But if you go, you get much closer, and much closer, and much closer, you see every single details so precisely and clearly. That's a good fresco. Well, not every single detail. I'm not Michelangelo, but I will do my best. I agree completely with what you say. Judicial independence is a lot of things. I said one of them. That is the most pressing in terms of structure of justice. That is, what does it make possible that you can circumvent without formally disregarding access to justice, emptying it of its core sense, political bias and whim. A consequence of that, even if not intended by the government or the states, or the member states, for example, is that judges that are in the European courts, even in the European Court of Human Rights, might feel themselves not coerced, but really under the eyes of Putin and of others political powers. But even if not so, you also mentioned that they have some values, and even maybe that sincerely they do all them through. Therefore, they go there with some ideas about the irrelevance of democracy, maybe, or certain kind of illiberal democracies that should be pursued. I mean, it is possible. But you see, this is unavoidable. The first thing has been addressed by my friends in Oslo, in the Arena Circle, that are working on how judges are recruited, how they are selected, who they are. You know, this is very important. But at the end, you can do what you can do. Not so much more than try to persuade for moral suasion more than that. You can't. Anyway, that's a relevant point. The second point is less avoidable. Because the values of a judge, it is her own cultural, legal cultures, convictions are something that you cannot simply exclude because you don't like them. If you look at how, for example, the European Court of Human Rights decides cases that are hard, in the sense that are controverted or controversial, you see that they use the doctrine that now is legally in the Protocol 15 of the Convention, the doctrine of the margin of appreciation. When they do so, they use a canon, and the canon is if the interpretation of a right has not gained enough majoritarian consensus among the states, then the margin of appreciation, so in other words, the discretion in understanding what the content of the right is permitted for the member state. But you see, we are living under this point. Judicial independence might have to live with this, at least what is unavoidable. But I distinguished between the two cases. We can make other cases also, but I agree that selection, and the proof of impartiality of a person is important. The virtue of a judge in these cases, the virtue that is, there was a theory on judicial virtue in the 80s that was going on, a virtue-centered idea of adjudication. Well, I was always skeptic about this, but still I understand that it is most valuable that a person is capable of impartiality. In that sense you were referring to. So for the other, we need a second session. The German versus Italy. Well, what was the situation? The situation was materially irrelevant. Italy had no interest to compensate the residual victims of the war crimes of Germany. But still, at the Tribunal of Florence, there were people going there to claim for civil compensation. Germany, that had been asked to compensate by Italy, by the tribunals of Italy, did go to the International Court of Justice and said, well, what's the fate of immunity if a state can be called to respond before an Italian court? There is a great logic in this, that is the logic of the immunity principle. The immunity of states is the consequence of the sovereignty of states and of the equal sovereignty on them. So you can't have a sovereign state that goes beyond, after, subordinate to the decision. Well, old and ancient tradition, the courts were under the purview of the king. So immunity was serving the autonomy of a sovereign vis-à-vis directly, not a court, but a sovereign, another sovereign. Anyway, this was the story. After the decision of 2012, the Italian parliament, that had no interest to this kind of dispute with the international order in the case, simply issued a legislation that prevented any kind of access to justice before Italian courts against Germany for war crimes. So that was it, finished. But we had the Constitutional Court. The legislation was claimed before the Constitutional Court by a judge of Florence, illegitimate, according to the Constitution. Because, of course, if you do not grant access to justice, then you are violating human rights, Article 2 and Article 24, access to justice. Then the Constitutional Court said, well, it was a very controversial decision, and there are at least 15 different interpretations by scholars of the same decision. What does it mean? What it means, what it doesn't. By the Constitutional Court. I assumed that it was a step that could be used objectively, regardless of the intentions of the judge that wrote it, as a step toward the understanding of what, in the relations between two different orders, each of them should do in order to understand the good reasons that are exposed by the other. The decision of the International Court of Justice was horrible, in my view, horrible from any perspective, simply because that decision did choose to decide on the basis of the procedural primacy of immunity. Therefore, since procedure is logically prior to the discussion of the merits, therefore there is no discussion on the merits, war crimes and crimes against humanity. So it's a matter of principle. The reasoning could have been really flawed, because after all, even the judges at the Italian Constitutional Court answered that it's not true that you can reject the merits, separating them. You can avoid treating the merits, separating them from the procedure, because there is a strict connection between the procedural part and the merits. Therefore, you can understand the first only by assessing the second. So that was the answer. Anyway, it was an horrible decision because, as it is typical to the way of procedural functioning of International Court of Justice, they do consider only the parts that are raised by the claimant. They do not consider, as in any other court or constitutional court, international law as a whole. Had they done so, they could not have simply said, well, there is the immunity principle, though that's it. No, they should have balanced and understood whether a war crime or a jus cogens rule can prevail or should not prevail vis-à-vis immunity of states. That is another fundamental principle. They could have decided in favor of immunity, but they should have reasoned in favor of it, not just, straightforward against.
Other questions? No? Okay. Now we have a coffee break, but before the break, I want to say thank you to Alessandra Facchi, to Nicola Riva, to Paola Parolari for involving me in this international conference as a chair, and enjoy your coffee, and the conference will start again at 12, I think. Okay. Thank you very much. Thank you very much to the keynote speaker. Thank you very much to the discussant. And now, enjoy your coffee.